So hi folks, so I thought I'd do a vlog. I've got a hearing today. I'm outside the Royal Courts of Justice at Central London County Court, and I've arrived way too early. And I've never actually done a little intro vlog about a hearing that I'm actually attending. In this instance, the barrister was unable to make it. I usually send barristers to deal with the court appearances, but today it's yours truly. And the reason I'm inspired to vlog to you about this particular case is I just think it's a sort of a gold mine of knowledge, of legal knowledge, of civil litigation procedure for litigants in person. But it's also a really interesting case for the purposes of those who are, facing court proceedings in respect of a trust case, contested will, property matter. So the area of law in this case is trust law, and I'm going to publish a vlog that will go into some detail into the various different areas, so that if you are dealing with sort of potentially a family dispute over wills or properties, then you'll get the skinny on that. I'll try and open the lid on this rather kind of seemingly complex area of law, of trust law. And I will also, so it'll be a bumper edition as far as Court Wingman is concerned. I will also deal with all the golden nuggets of legal knowledge as far as litigants in person are concerned that that arise, because this case has been running for nearly 4.5 years in this court, has become a kind of a smorgasbord of, really quite truly, every single little challenge that you might face, not just as a litigant in person, but as a lawyer, as a solicitor. And so I hope that vlog will also be of interest to trainee lawyers and indeed lawyers themselves, because we never stop learning, of course, and in particular we never stop learning about the, how shall I put it, the dogfight, because I'm so often beating this drum. Civil litigation is not about justice or any lofty ideals and principles. It's an entrepreneurial endeavour. It's about taking a calculated risk and being commercial about the whole thing. And today I've been yesterday quite commercial in making some quite low offers in this case, and I'll just tell you quickly about what this case is all about, and then I'll finish by telling you what today's hearing is about. So why this is such an interesting case is, for me, it's quite morally kind of repugnant. Can't think of a better word, what has actually happened. But nevertheless, even though there's a lot of moral force in our case, we may lose for various reasons. But from the legal perspective, as far as trust law is concerned, because it's a relatively old case, been a lot of water under the bridge, documents aren't easy to retrieve. Our client, an old lady, died during the course of these proceedings, so we're now representing the estate. In a way, we're representing a professional executor, and one of the beneficiaries, or the only beneficiary of her will, is a grandson. So we're kind of fighting the case for him and his executor. And also the area of law is not straightforward, because in our case, and I'll give you the story, you've got an arrangement. So you've got a grandma who 10, 15 years ago had a will in which she left the large family home in which she lived in to the grandson, and the smaller property to the granddaughter. She had a small flat which her deceased husband had left her. She owned properties outright. Yeah, no mortgages, no charges on them. She loved her grandchildren. She kind of looked after them. They came from a broken home. So she wanted to, at the granddaughter's request, she was the older of the two. Grandson was still at university. She wanted to kind of bring forward the will, and the granddaughter either asked or was very happy for the will to be brought forward so that the granddaughter could get her property early, as it were. In the event, actually, she didn't want to move into that property. She ended up buying another property. This is all in London, using the deceased husband's property as collateral, raising a mortgage on it so she could buy the place that she wanted. The grandmother, our client, deceased, put her trust in her granddaughter, reposed trust in the granddaughter, and our case is that the granddaughter then went on to breach that trust. He owed a fiduciary duty to her grandmother and indeed to her younger brother to meet the terms or to give effect to the understanding that the family had around this issue. Yeah. So then the next thing that happened was in 2012, the will was about 1997, the granddaughter wanted to move into the family home with the grandmother. And basically, by this point, the grandmother had given sort of power of attorney, if you like, to her granddaughter and put her on the title deeds of the family home and the deceased husband's property. Then what happened was, the arrangement was that the grandmother would move out to a kind of a granny flat, a smaller property, and allow the grandson and the granddaughter to live in this property. But the idea was that the granddaughter was holding the big family home on trust for her brother, because she already had a property. To cut a long story short, 10 years later, when we brought proceedings, the granddaughter owns the family home, sold it last autumn for over £900,000, probably equity of 700 to 800,000 because the mortgage was quite low. Still owns that property that she wanted because she didn't want the deceased husband of grandma's property. Still owns that, value of, I don't know, 500, 600,000. And has over time, because the grandson's a bit of a hopeless individual, sort of shelled out cash to him, a total of £140,000 over a number of years, over the 10 years, and left, and grandma, when she moved out of the family home into her granny flat, because the granddaughter, our cases, actually overextended a mortgage on the granny flat, took a lot more out of that granny flat, so the mortgage was very high. She couldn't afford to live there and had to sell and downsize, and the granddaughter wasn't helping. And then the granddaughter, whose name was also on the title deeds of the deceased husband's property, she sold that and didn't help out grandma. Grandma ended up living in a lease for life property. When she died, she only got approximately £15,000. She only had a sort of like a 10% or less interest in the property. That's a special lease for life arrangement that one can have. So the estate ended up with very little, in fact, and a lot of the estate money had gone on legal fees. Some of it was given to the grandson. But when she died, it was only about 50,000, 60,000. Meanwhile, the granddaughter is sunning herself financially, at least, so it seems to me, although her case is that it was gifted to her, it was sold to her, there was no trust, and that she's been hard done by, and it's all a revenge plot by grandma And of course the grandsons got very upset and actually got charged and prosecuted for criminal damage, because the idiot went round to the family home that the granddaughter had managed to get him out of a couple of years ago, and he smashed the place up. So, I mean, quite an interesting case. From where I'm standing, but then a solicitor is always quite close to their case and their client, but for where I'm standing, it seems like an outrage. But from the law, there's no trust deeds, there's no letters or legal documents that formalised this trust arrangement back in the day. And of course, our client has passed away. We're hoping that the facts will speak for themselves to the court when it comes to trial in a week's time, on the 29th of September, a 4-day trial here in Central London County Court. But to come on to today's hearing, the granddaughter, who's a litigant in person representing herself, which is why I think this is really interesting for the channel, has brought an application as a result of the judge at a hearing 2 weeks ago saying, I think there may be a limitations issue in this case that's never previously been raised. She's brought an application to amend her defence and strike out the claim because it fails for limitations, i.e. the case was not brought quickly enough after the cause of action had accrued, after there was a case against the granddaughter. Approximately 6 years, although it's quite a grey area. So we've never felt particularly concerned about this possible defence of limitations, but it's all expensive, and I've had to come from Poland, in fact, for this hearing. And this has been the kind of almost like the incredible feature of this case has been the number of hearings we've had, the amount of sort of obfuscation, roadblocks, obstacles the litigant in person has put in our way, how the costs have ballooned, and in short, in order to do right by the executor, who if he loses faces a legal bill personally. That's the thing about being an executor. He felt duty bound to bring this case against the granddaughter. Anyway, the long and short of it is we made reasonably low offers yesterday, and almost painfully low, frankly, because I don't really want to have to, solicitors must have their clients' best interests at heart. Anyway, that's a little update, and I better now settle down in the pret-a-manger here with my papers and make sure I'm properly prepped for the hearing, which is about an hour long, going to be taking place inside Royal Courts of Justice in about an hour's time. So stay tuned for the result of this. It's very emotionally demanding case, this really difficult, one of the most difficult cases I've ever had to run. Stay tuned for the outcome, but also most importantly, stay tuned for all the golden nuggets of civil litigation knowledge that you can glean from a future vlog. So from the Strand Royal Courts of Justice on a beautiful and sunny autumnal morning. Bye-bye.